Gorsuch? Justice Kavanaugh?
I think the key word is otherwise, and trying to figure out what that means under our established principles of statutory interpretation. It would seem to trigger justum generis under the Begay precedent, and you've used the phrase a few times, catch-all provision, as does your brief, and Scalia-Garner book describes justum generis as how you interpret catch-all provisions. Does justum generis apply here or not?
No, we don't think it can sensibly apply here. So the court has said many times that otherwise is a natural way for Congress to create a broad catch-all category. And I certainly don't dispute that there can be situations where you have a parallel list of nouns or a parallel list of verbs where the court might further think that justum generis principles apply. But that's just not how 1512C is structured. It has, as I've mentioned, its own complex internal structure. You know, you've got the mens rea requirement that's unique to C1, and Congress did not transplant that into C2. That triggers the other canon that when Congress uses disparate language in two adjacent provisions, usually it means something by that. So I think that this just isn't the kind of situation where the court could sensibly apply justum generis. And the other thing I would say is that, you know, if the court goes down the road of trying to glean some kind of requirement from C1, the other reason the canon is inapplicable here is that it's not evident on its face what the common attribute would be, and that just relates to the Nichols-Katz's dispute.
As you know, that's true in almost every justum generis case, and the treatise explains that as well, which is it's hard sometimes to figure out what the common link among the words in the phrase is. So I don't think that point I don't think distinguishes this case from other justum generis cases, but you can respond to that.
But I do think that a plain speaker of English would recognize that usually the common link or the connective tissue is the language that follows the word otherwise. That's the congressionally approved similarity. That's what C1 and C2 have in common. They both relate to obstructing an official proceeding. And, you know, I recognize that petitioner has invoked Begay. Your question touched on it. But the statute in Begay, which we think is not the model of statutory interpretation to follow here, the statute itself was relevantly different. It had a list of nouns, and so it was the kind of statute where potentially a justum generis could apply.
What about the contextual points, a couple of them that I think have come up, but I just want to make sure you have a chance to respond? That it would be odd to have such a broad provision tucked in and connected by the word otherwise.
I don't think that the placement in the statute is odd at all for a couple of different reasons. One is the point I was trying to make to Justice Kagan about this court's own recognition that 1512 is one of the big obstruction statutes. This is the statute that is aimed generally at official proceedings. It's not more discrete, and there are other provisions like 1519 and some of the ones that come right before it that are more narrowly confined and are intended to reflect discrete circumstances. That doesn't describe 1512 at all. So when Congress was trying to broadly prohibit obstruction of official proceedings, 1512 was exactly the right place to go. Then petitioner says, well, Congress buried it in the middle of the statute. But I think it's actually quite explicable when you look at how the other provisions are structured. 1512D, which I was discussing with Justice Alito, has a much more minimal penalty and doesn't require the intent to obstruct. So it made sense to put 1512C before it, but also after 1512A, which is the most serious obstruction, like killing a witness, punishable by 30 years or up to life.
Last question. There's 6 other counts in the indictment here, which include civil disorder, physical contact with the victim, assault, entering and remaining in a restricted building, disorderly and disruptive conduct, disorderly conduct in the Capitol building. And why aren't those 6 counts good enough, just from the Justice Department's perspective, given that they don't have any of the hurdles?
Because those counts don't fully reflect the culpability of petitioner's conduct on January 6th. Those counts do not require that petitioner have acted corruptly to obstruct an official proceeding. And obviously, petitioner committed other crimes that we've charged and that we're seeking to hold him accountable for. But one of the distinct strands of harm, one of the root problems with petitioner's conduct is that he knew about that proceeding. He had said in advance of January 6th that he was prepared to storm the Capitol, prepared to use violence. He wanted wanted to intimidate Congress. He said they can't vote if they can't breathe. And then he went to the Capitol on January 6th with that intent in mind and took action, including assaulting a law enforcement officer, that did impede the ability of the officers to regain control of the Capitol and let Congress finish its work in that session. And I think it is entirely appropriate for the government to seek to hold petitioner accountable for that conduct with that intent.
And are the sentences, the sentence available is longer for this count than for any of the other counts or all of them together?
The statutory maximum is higher, but after a recent decision in the D.C. Circuit, which held that a particular sentencing enhancement doesn't apply, that was the Brock case, I believe the sentencing range, the guidelines range for the assault count would actually be a higher guidelines range. And just to give you a sense, for a typical January 6th defendant, someone who doesn't have a prior criminal history and who committed violent conduct at the Capitol, accepting responsibility, I think the average guidelines range or the range that would yield is 10 to 16 months of imprisonment. For someone who didn't commit violence, it would be 6 to 12 months of imprisonment. We've looked at the average sentences here. There are about 50 that have gone to sentencing, conviction and sentencing on just a 1512C2 as the only felony, so I think that's the best way to gauge it. This was when the sentencing enhancement did apply, so the ranges were higher. The average sentence among the approximately 50 people is 26 months of imprisonment, and the median has been 24 months. So there's no reasonable argument to be made that the statutory maximum here is driving anything with respect to sentencing.
Thank you.